So let me just kind of go over myself. I started in 1987 with Arthur Young and Company, and as a CPA in Tulsa, Oklahoma, one of the clients I audited was the Williams companies, and it's called Wiltel. And so what we did is that was my introduction into telecom, and then I basically was an ILEC, an incumbent local exchange manager, accounting manager as a CPA. And we did a bunch of rate cases with the Florida Public Service Commission and things of that nature. Right now, I run a company. We have about 300 clients that basically, they range from very small to very large in compliance nature with what you have to do with the Secretary of State, the Department of Revenue, and the Public Service Commission. And of course, that includes all these different forms that you have to fill out. And so, anyhow, so that's just kind of introduction for myself. And Janelle, you want to go ahead?
Greetings, I'm S. Janelle Trigg. I'm a partner at Lerman Center. You all know my colleague, Steve Coran. I'm chair of our privacy and data security practice. I'm also a certified information privacy professional. What's unique about me is that I spent almost 20 years on the broadcast side of the business with sales and marketing. In fact, it was FCC rules and regulations that drove me to law school, because I could not understand some of the stupid decisions that the FCC had. So as an alternative, I also worked at the FCC so I could get a little internal knowledge. I had the pleasure of clerking for 2 FCC commissioners and then spent some time as a senior policy analyst. I was also former assistant chief counsel for telecommunications for the Small Business Administration. Small businesses have been an important part of my practice from day one. And I encourage you to, again, ask some practical questions and things that we can take back to the FCC and let them know what the real world looks like. We've got a fast and full agenda. I mentioned this is the lightning round. We're not going to cover everything in detail. These slides will be available on WISPA's website. So we're not going to cover each slide in detail. That would be a 4-hour session as opposed to a 1-hour session. But it will give you some information to go back to. Mark?
Okay, great. Okay, thank you. All right, so we're going to going over just some information related to what VoIP providers have to do. Every year there's a 499A return that's required. It's annually, and then on a quarterly basis you file a 499Q. Okay. Okay, oh, the agenda, I'm sorry. Okay, so we're going to go over the 499, we're going to go over registered agent, service and process, access to portable numbers and all that. If we go down toward the bottom, we've got broadband internet access services. We have, and then information related to the privacy policy, CALEA compliance, things of that nature. You can kind of read the screen there or whatever. That's kind of what we're going to try to cover in the agenda. Okay, disclaimer. Remember, this presentation is not intended to create attorney-client privilege or anything like that. So we're just giving information as much as we can, okay? There is opportunities later, if you want to come up and talk to Janelle later and things of that nature. The information in this presentation is general and is not offered as a legal or a CPA or financial advice. You're strongly encouraged to consult with your professional. Attorney or CPA or whatever, and any reliance on the information is kind of taken at your own risk. This is just information, okay? All right, now, this next slide is kind of an overview, a little bit of what you have to do. I know it's a little bit small, but it lays out the different agencies, okay? Your one agency is going to be the Secretary of State on the left, then you're going to have your Department of Revenue in the center, and on the right, you're going to have your regulatory commissions, so your FCC and your state public service commissions. Now, not every state commission requires you to register as a VoIP, okay, or as a wireless provider. Some do, but basically the FCC is they're the regulatory body for VoIPs and for wireless, okay? President Clinton did this in 1993 with the Omnibus Budget Act related for wireless carriers. And in basically 2001, 2002, when Vonage wanted to basically not have to apply with the registration with all the different state public service commissions, they went to the FCC and asked them to regulate them, which the FCC generally did, said as long as you contribute to the Federal Universal Service Fund, we'll be more than happy to regulate you. And so the states, and there's been states that have basically, Minnesota, for example, who has laid off a lawsuit with the FCC to try to get their saying you can't control VoIPs in my state. Basically, the federal courts have ruled in favor of the FCC. So for voice over IP, it's regulated by the FCC. All right, now, these are a listing of states that require wireless and VoIP registration. It's just a listing of those or whatever. You can see there's about between 18 and 20 or so around there. It's good. You know, then we can go to okay, and now this next slide is just an example of a lot of times people come up and they say, well, how do we bill for this? And how do we actually remit things? Realize that most of these things are called fiduciary taxes and surcharges, okay? So let's talk about this just for a second, okay? In essence, on a bill, okay, from a cash flow perspective, you've got three things that go in a bill. One is going to be legislative branch taxes. These are things that are proposed by the House, approved by the Senate, and it's signed off by the governor. Those are legislative branch taxes. Those are sales tax, communication service tax, property tax, corporate income tax, 911 tax, things of that nature, right-of-way tax. The second thing is called executive branch surcharges. Now, the executive branch of the government would be either the president or it'd be the governor. Now, the president or in the states, for the governor, that's called the Public Service Commission. So a state universal service fund is not a tax, it's a surcharge. And the federal USF is a surcharge as well. The reason why that's important is because when it comes to having an audit, which we defend a lot of companies in audits, those revenues that are surcharges are subject to tax. So like in New York, you're going to have New York sales tax is going to apply to a federal universal charge on a customer's bill. Now, the third thing that's on there are what's called, I'd call them company-imposed junk fees. So if you throw a regulatory recovery fee on there or something like that, those are another surcharge, but they're company imposed, they're not government imposed, okay? So this right here kind of tells you in a listing of what you would have as far as taxes and surcharges. Now the first taxes and the government surcharges in here, and it'll tell you what the rates are and things of that nature, okay? So this is a lookup tool. It's a lookup tool we have out there all the way through to assist you in billing and collection. Remember, these are fiduciary taxes, or fiduciary surcharges. Pardon? Oh no, if we have it internal, we have it. You can come if you ever come. We can show you a listing how to do this. It's out there on my website if you want to. I don't want to make this an infomercial, but that's available. Okay, now the next thing is going to be just kind of a context view. Okay, and this is basically the Federal Universal Service Fund existed prior to 1988. Okay. But primarily, the companies that were imposed, that were paying into it, were Verizon, Bell Atlantic, the ILEX, AT&T, Sprint, MCI. You remember those days. Okay, 1999 forward, it was opened up to everyone, okay? Now, you can kind of see the rates. Look at the rates and kind of how they've gone up. Back in the day, in 1998, when they were about 4%, this is when ILEX paid into them. Okay. Now, ILEX have a strong lobby in D.C., and they basically said, FCC, you have no control over intrastate traffic. Remember, there's jurisdictional traffic, intrastate, interstate, and international. So the FCC governs interstate and international commerce. So what we have here is that we can see that the rates were low at around 4%. When the ILEX won the case against the FCC said they needed all this money. As they got this, they needed this the big pot of money. So immediately the rates jumped up to almost 10%. Now you can see that right now they're at 18.8%. Okay, they're well up there, and they keep rising. Okay, so what you have to do as far as for registering with the FCC or with the Federal Universal Service Fund is you need what's called an FRN number, a federal registration number, and then to file to get a USAC number or a federal USF number, you basically fill out pages 1, 2, 3, and 8 on the form, on the 499A form, and this is out there at the FCC website. The agency called Universal Service Administration Company, USAC, that is the agency that the FCC has outsourced to basically to handle all this. Very similar to the U.S. Treasury, they outsource things to the Internal Revenue Service. So the Internal Revenue Service is quasi-government, they have all the powers that are necessary to do this. Okay. Then VoIP providers have to file the 499A return on April 1st, due April 1st, and that's for the prior calendar year numbers. And then on a quarterly basis, they file the actual numbers for the first quarter. It's due on May 1st. The second quarter is due on August 1st, and it goes like that. Now, the way this works is, the way that it happens is that you project your interstate international revenue. When you project that revenue, you're going to get a monthly bill from USAC, okay? This is, I'll use an analogy. It's very similar to you and your own individual income tax returns. If you have a payroll, okay, or you know, let's say you're an employee of somebody, you basically tell them how much federal withholdings you want withheld. And let's say you get paid twice a month. So now we have 24 pay periods, okay? So you pay in those 24 pay periods. At the end of the year, you file what's called the 1040 return, okay? The 1040 return is very similar to the 499A return. It's a true-up, and you're basically comparing what you actually made versus what you actually paid. And then that's what this is. There's a lot of complications with it, but in essence, in a nutshell, that's the executive summary of it. Okay, now on the form, one of the things that you have to do with the FCC is you have to have a DC agent. Okay, a registered agent is based on English common law, which basically says if you have an entity or corporation or an LLC or a partnership in a state, someone has to be able to serve legal summons on them. Okay, subpoena powers and all that, and it can't be a PO box. So you would need to have a registered agent that has a street address in DC. Okay. And that, I'll let Janelle explain that a little bit more, but that's just a requirement, okay? All right, now, if we go to the next. Okay, now, these are the portable numbers. Basically, prior to a certain date in 2015, June 22nd, 2015, you kind of had to go through an intermediary to get a block of numbers as a voice over IP provider. That kind of gatekeeper wall was pushed down there. Now, as long as you're basically the second bullet point, as long as you're for the most part registered with the state commission, then you can go ahead and get those numbers. That's been yeah. Go ahead and ask a question.
Do you have to be a CLEC to do all that?
Okay. The question is, do you have to be a CLEC to do all this? You used to have to be a CLEC to do all this, but now you don't. Now you can be as a VoIP provider. You can get those numbers. Mm-hmm. Okay. That's it? Okay. All right. So now there's other basically requirements that we have to keep track of as you have those numbers. You have to comply with number utilization and optimization requirements, kind of the ResBorg and things of that nature. You have to file a request for numbers at the relevant state commission 30 days prior to requesting the numbers. You have to provide contact information. These are all those things that, as like an ILEC or a CLEC, if you're asking numbers, you'd have to do. They need to know what those numbers are so that they know who they're porting them to. You need to provide proof of compliance with the commission's facilities readiness and with those rules. So that all this implies that you're going to have your Secretary of State, your service and process with the state, and all of the different things with the commission, the state commissions. Yeah. Okay. And this is typically what happens with the commissions. One of the main things that the different commissions are looking for, they're looking for three things: your managerial, your technical, and your financial credibility. This is if you're going to get an ILEC, if you're going to get an ILEC, if you're going to go to be a toll reseller. I used to do this for a living as well for a couple years in all the different states, is you have applications and tariffs. And so one of the things they do before they approve an application, they want to see if that's what you have. And there's just, there's a pro forma financial that you file, your managerial capability. Maybe you're using, for example, as your underlying carrier, maybe you're using NetSapiens, you're using Level 3, or you're using whoever. That could be your managerial capability along with you knowing how to run a business, okay? So that handles the technical and managerial capability. Okay, and so then providers must submit an application with the FCC into the VoIP authorization application billing. interconnected VoIP providers obtaining numbers directly from the North American numbering plan require you to provide contact in the relevant states and the requested numbers that you own your own operating company numbers. Okay, need 911 registration? Yes, go ahead, sir. Okay, the question is that do you have to go through an intermediary to get an OCN like was required in the past days?
I'm not sure.
Yeah, I'm not 100% sure on that one either.
That's your key to a lot of the databases. You gotta have an OCN or you're not, you can't even create an entry database. That's the index for the database.
Right. I know when we do the applications, and tariffs now, and for the most part, the key has been you have to have a CLEC. Now, you can file a CLEC application, and everything doesn't have to be on the tariff. You can do an ICB. Everything's an individual case basis. But for example, like Louisiana or Florida or whatever like that, you kind of have to have that. Yes. 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 Okay. All right. CP&I, there's a whole requirement to handle CP&I policy and registration and making sure that you're in compliance with all of your customer proprietary network information. Once a year, you have to file a certification with the FCC, but 365 days a year, you have to make sure that your network is in compliance. And if you're out of compliance, you have to report that to the FCC. Let's say there's a breach or something like that. Okay. The annual certification, record keeping is reinstated for all communications and interconnected VoIP providers. I'll just read this real quick. Was eliminated by privacy rules. Biased providers are still classified as telecommunication providers under the 2015 Open Internet Order, subject to Section 222 CP&I requirements.
So basically, there was good news, bad news when Congress dissolved the broadband privacy rules. The good news was that the privacy rules were dissolved. They were very onerous, if you remember WISPA America was talking about that. The bad news was the old rules then went into effect, which means the old certification requirements are now in play. So now, as a broadband service provider, you have to file that CP&I certification where you didn't before.
Okay, international traffic report. Providers must file a report to the FCC July 31st with the traffic you have to various countries. Actually, a quick update to this. The FCC staff has basically waived part of this requirement if you're below a certain dollar amount, so they basically will give you like a voucher type of thing to reduce the requirements on that. Okay, network outage reports. This is something that you're required to 365 days a year. You have to basically, if you have a network outage or your underlying carrier, your upstream provider has a network outage, there's things you have to report to the FCC. The FCC wants to know about anything that affects consumer services. They want to know whether there's a breach in service or something like that. So this is kind of a little bit onerous. You want to make sure that as you're selecting your underlying carrier, that they have procedures in place to report to you to let you know. Now, obviously, your customers are going to complain to you and say, hey, the network's out, okay? But you may not know, is it out because the electricity's out, or is it out because the provider has a glitch in their system? So this is one of those things you want to make sure that you have in place, ready to go in case you have to report it to the FCC. Okay. Yes, sir. Yes, ma'am. Okay. The question is that how deep does it go related to reporting, related to a network outage? Okay. Go ahead.
It's the second bullet in terms of an outage is reportable if it's at least 30 minutes duration, and if it potentially affects at least 900,000 user minutes. And you have to multiply it by your subscriber, number of subscribers, whatever. So, if it's a blip, no, it's not reportable. It has to be a bit more substantial. You're welcome.
Yes, sir. Okay, the question is, is there an assumption of liability related to an outage and related to 911? Okay, so somebody's trying to get to 911, the network's out, they can't get to 911. What's the liability there? Okay, would you like to tackle that one?
You know what? I'm not really sure, but I can't imagine that if you have taken reasonable measures and these are circumstances beyond your control, that there would be a liability issue. If you have not taken proper managerial, technical, and security reasons, or you haven't done your due diligence on the proper underlying provider, that they are able to provide the system on a regular basis, I would presume there could be some liability, but I don't know of any cases or any other documentation for that.
Yeah, and just one follow-up question. Would the concept of an act of God, would the concept of an act of God fall under that response you just provided?
I think an act of God you have no control over. I'd like to say we do, but we really don't.
So just for the record, for the folks who are taping this or whatever, the question was, does an act of God overrule a little, what this is? And I'll just give you my 2 cents from the answer there. But we're in Florida. I'm in Florida. We have a hurricane that just came through there, 4 or 5 weeks ago, and then one just swam by. As the IRS basically gave a stay on anything that was due for taxes. The FCC did that as well. I've had to file a revised 499Q for a company. And initially they came back and their systems were all set saying, you filed this after September 15th, it's rejected, your revised filing. I went back to Fred, who's the head of over there, and I said, Fred, I thought the IRS granted us 5 business days. I'm in Florida, I'm in Florida. And he came back like 2 days later and said, yeah, you've got complete access. So I think the spirit of what Janelle says is 100% right. As long as you're substantially compliant, that's the big thing. No one control acts of God.
That's why they're called acts of God. Let's talk about Form 477. This is the fixed broadband deployment data. The Commission issued a new NPRM, I'll talk about that in a minute, that are looking for more detailed data. But basically 477, it's required of all facilities-based broadband internet access providers filed 2 times a year. You must report where your internet access is offered at speeds exceeding 200 kilobits in at least one direction. Fixed has certain requirements, mobile has certain requirements. This further notice of proposed rulemaking was issued in August. Comments we filed, WISPA filed comments just yesterday. This NPRM is pretty onerous. They're asking some proposals, they're asking questions as to what degree that you can provide more granular data when it comes to not just existing customers, but potential customers, particularly at the sub-census block level, including street addresses and/or road segments. They want to know whether a fixed wireless broadband provider, should you be required to identify certain potential subscribers in your census block or via a street address or road segments. They seek comments on specific costs and burdens for such reporting. They also ask whether geocoding should be required for all potential subscribers in a census block or service area. Let me tell you what WISPA responded to. Again, the filing was just yesterday. We said that basically you, FCC, are confusing fixed wired services with fixed wireless. The questions about road segments and street addresses are more applicable to cable and fiber and things that run along a road. It does not work for wireless. A fixed wireless provider, you only know, what street addresses that your existing customers on. It would require you to take boots on the ground, in Mark Radabau's language, that you would have to drive around your entire service area trying to determine the street address where there is a street address. And then, even if you had a street address, you would have great difficulty in ascertaining whether service will be or would be available, at a particular new customer. You could not do that without being actually on the premises and in an installation aspect. You need permission from the homeowner or the property owner in order to stand on a roof or try to find out where you can connect your access point and your customer's antenna. So it is not only onerous, it's not only expensive, it's inaccurate. It's impossible to determine what type of accuracy, what type of probability you can identify existing customers, particularly when you have to certify on your FCC 477 form that this information is accurate. And that service form is also subject to penalties if you don't provide accurate information. We said, FCC, this makes no sense, it's burdensome for small providers, and it's not realistic. We did argue that the Latin long was maybe a bit easier for geocoding, but even still, understanding where a street address is very difficult. The FCC also asked whether or not the reporting for 477 should be on an annual basis as opposed to a semi-annual basis. WISPA's position is it should be retained at a semi-annual basis. We understand that it's expensive for many providers and time-consuming. We actually did a WISPA survey. Many of you answered that survey to ascertain how much you spend on your FCC form compliance per year, how many hours you spend. But if we want this industry to be treated on a reliable and credible basis and to have accurate data as to where your service is, we think a semi-annual basis is better to do that. That data is more accurate. Yes, sir. If you're late in filing your Form 477, it's not clear with this administration. The previous administration actually penalized late providers to a tune of thousands of dollars or more. If you file it as soon as you can, that's better than not filing it at all. But this administration, we're not sure of what their enforcement aptitude is yet. 2010, no, but I think this is out of order here. Another notice. We got a chart in the wrong place. This is what we had talked about for comments. We also encouraged the FCC to eliminate some of the significant burdens on small providers that incurred an enormous regulatory cost when the form was revised. Many of you who are in business, that form was revised in 2015 to include census blocks. Allocating by census blocks is tough. You have to do your RF propagation model, and then you have to go back to determine where the census blocks are. We recommended that you be allowed as an alternative just to submit your polygon, whether it's on a raster's level, whatever, as opposed to having to break it down by census blocks. So that way it's easier for you. It's one step less to have to comply with 477.
So we're expecting the ruling on this
Well, reply comments aren't even due yet in 2 weeks. We'll see.
sometime around the end of the year, maybe we'll have a change.
We have no idea. We have no idea how fast this new administration will work. You can understand they've got a couple of major proceedings pending, the net neutrality. But the staff is pretty active trying to get this thing done sooner than later because they want your filings to be complete and stay on a regular schedule.
We haven't got the staff like they did in some agencies and left them unable to do anything.
Okay. Well, and the previous question was whether or not we'll get a decision in the next year. It may be faster than we think, but again, we can't control FCC staff. I wish. We mentioned about enforcement failure. Back when it was the old Enforcement Bureau, the gentleman that asked the question, what are the penalties? Again, it was a $10,500 civil penalty, but we're just not sure what they're going to do this year. Okay, let's go back to the 2010 Open Internet Transparency Requirements. These were the ones set forth in the now defunct, I believe it's Verizon case. You are still required to comply with the 2010 transparency requirements, and that includes small providers of any size. That post-open internet compliance statement on your website, the safe harbor nutrition label, we have an example of that. That under this administration, which pretty much rolled back some of the quote-unquote enhancements of the previous administration, You don't have to do that anymore. That's an optional thing. It's not required. 2015 Open Internet enhanced transparency requirements. Fortunately, small providers and WISPA, I can tell you, fought vigorously to get the small provider exemption. If you have 250,000 less broadband connections, you do not have to comply with the enhanced transparency requirements. Again, the waiver is for 250,000 or fewer. Please note that this will be based on your Form 477 filing, which is the reason you want to file it on time, because you don't get to benefit from the waiver unless you file your 477. One of the good things about this administration, the new Chairman Pai administration, is that we got a letter dated December, just before transition, and when we knew the results of the election, that they were very pro-small business and very much concerned about small providers, and pretty much assured us that there would not be the onerous enforcement actions that then the current administration had taken. And the quote from that letter I thought was important. In fact, I'd like to remind Chairman Pai on how important small business is so he can remember things in other proceedings about the importance of small entities. This is the broadband label. Again, it was created with input from the FCC Consumer Advisory Committee. This is no longer required. You can basically set forth your network management and your terms the way you wish. Love the FCC. All providers, you must have a terms of service and a use agreement, and ideally for your service and for your website. Remember, although the broadband privacy rules were rolled back, the net neutrality rules have not yet been rolled back. There's been an effort to do so. There's been an active notice proposed rulemaking. The current administration does not like the net neutrality rules, but the state of the law today is you are still a common carrier. You are still a telecommunications provider. And under those regulations, as well as many state laws, you have to have a privacy policy, and you also have to have terms of service, some written documentation of what you're offering consumers. This should be available on your website so a consumer knows exactly what your rates and terms are. You want to put all your legal documentation in there, where your venue and jurisdiction is, if there's a dispute, whether there must be an arbitration agreement. These are legal provisions that will protect your service and give consumers notice as to what the degree and parameters that your service are. Yes, sir. Okay, the question is whether there are certain requirements that have to be, I'm assuming, the terms of service, use agreement, and/or privacy policy, and whether WISPA has certain samples. Yes, there are certain requirements. Your rates, your terms, under what condition you will cancel or you will suspend a subscriber, when you will give notice, how you will give notice of a change of rates, whether they have a right to opt out, opt in. And then for privacy policy, the fundamental things are how are you going to use a customer's what I call personally identifiable information. Now, under the broadband privacy rules, there was such a thing called CPI, which was customer proprietary information, which was a broad scope. Those privacy rules are gone, but the concern is, or the problem is, anything that identifies the consumer address, phone, email, and anything related to those or linked to that data is all deemed to be about a particular consumer. So you have to discuss how you collect that data, who you're going to share it with, how you're going to dispose it or secure it, how you're going to use it, and in what condition can a customer have their information reviewed or deleted. State law also governs privacy policies. And you'll find more states have gotten more active in internet service provider policies because of the blow up on the demise of the broadband privacy rules. In fact, there were at least 22 states that have been trying to get the FCC's old broadband privacy rules, ones that are now dissolved by Congress, reinstated at a state level, which means now you're going to have state requirements that are going to be as bad as the federal requirements, but on a state-by-state level. And for those of you that are operating across multiple states, that makes it very onerous. So your privacy policy you really need to be, it needs to reflect your actual business. That's why WISPA does not have a privacy policy model, because it depends on what your business is. Just curious, how many of you have a privacy policy posted on your website? Okay, about half the room. How many of you borrowed that privacy policy from someone else's privacy policy? You don't have to raise your hand. I know it's probably the same folks. If you haven't read that privacy policy, and if you don't understand what it says, and you just plugged your name in at the top, I can't tell you how many privacy policies I've seen that it was borrowed, and the source, the original source of the privacy policy is still incorporated throughout the document. So the name of the company you stole it from, basically, is still inserted in your privacy policy. In terms of posting your AUP on the website, what conditions or restrictions?
I guess I would have to do net neutrality too, some of the AEP stuff.
Well, I don't know of any restrictions that the FCC has in terms of posting it. In fact, I believe they encourage you to post it because they want customers to know in advance. But in terms of your network management, since the net neutrality rules are still in order, you still have to describe what your network management practices are and why you do certain things. But that, I don't think there's any restriction at all of any government agency putting forth customer-based information in advance. So that way a potential customer can take a look at your website, see what your services are, your conditions, and whatever, and compare it with someone else. Which is why the whole broadband consumer label came up. They wanted consumers to be able to compare internet service providers' terms with others, and they wanted to do it in a standard format. Again, that standard format is not allowed, but the posting is very much encouraged. You're welcome.
It's not allowed or not required.
I'm sorry, posting?
The standard format.
Standard format is, it's not required, correct. I'm sorry, the question was the standard format not allowed? It's not required anymore. It's optional if you wish to use it. Something obscure you may not be familiar with is the FTC. Now we've got another federal agency involved. Federal Trade Commission has what they call red flag and address discrepancy rule. Basically, if you're a creditor, and a creditor, it basically is defined if you are if you're providing a service and someone pays you after the fact, you are a creditor. You should have certain provisions in place to make sure there's no identity theft. In terms of address discrepancy, there are a lot of people that have the same name. They want to make sure that before you take onerous action or take some kind of identification theft or report someone to a consumer reporting agency because they have failed to pay your bill, that person is the right person at that particular address. They also have a whole requirement that you should have a program to identify ID theft within your system, which means that your accounting department should be able to recognize where there's a red flag that comes up if there's indeed a potential ID theft. Yes, sir?
Am I a creditor if I don't pull a credit report on a customer and I merely have unpaid for the next month's service?
Yes. It's not based on pulling a consumer report. It's based on when you get paid and how you get paid. I'm sorry, repeat the question for the, I'm so used to answering the question. The question was, are you a creditor? If you don't pull a consumer report and you barely require the customer to pay after the fact, correct? Did I get that right?
Yeah, if I bill in advance for some part of the service and in arrears for the other part of the service, I'm still a creditor.
Yes, you're still a creditor even if you bill in advance for some part of the service and arrears for the other part.
At that point, the only we don't have a liability.
Well, in the billing example, that you don't have credit card information because you're PCI DSS compliant, which is a good thing. You don't store it, but you only have name, address, and maybe email address. You have no other payment mechanism. You're still a creditor, unfortunately.
But in essence, that's all I can guard. Is that what sort of like?
In essence, that's all you can guard, which will make your program very easy to design. Okay? The Commission, the FTC, does not distinguish whether you use, which is Payment Card Information Data Security Standards, PCI DSS, which is basically another set of regulations that the credit card companies have devised, Visa, MasterCard, American Express, Discover, that you have to comply with when you're doing credit transactions online. There's a whole series of standards, otherwise you lose your right to conduct with credit cards, and you also have to pay serious penalties, more so than the federal government penalties. The credit card companies are not playing. Yes, sir? Well, you would have lesser liabilities. The whole purpose for the red flag program is to ensure that someone doesn't use someone else's credit card or someone is not paying for someone else's bill. It's not to solve the entire world problems with ID theft. It's more specific to, again, as a creditor, to someone that's paying the bill or not paying the bill, or check fraud even. It doesn't have to do just with the credit card. It has to do with also check fraud. Okay? Access for disabled persons?
Okay. Okay, then several more requirements. 3 I'm going to cover basically. So access for disabled persons. This is a report that you have to file April 1st every year. It basically goes through the operating procedures of making sure that there's nothing, or you certify there's nothing that goes against that you're kind of basically discriminating against disabled services that are out there. For 2017, only VoIP providers are required to file the certification. For 2018, VoIP and BIA providers will have to file this.
Is this regarding my employees' access to stuff like EDA, or is this something to do with customer disability stuff?
It's customers. Yeah. Again, kind of remember the common focus of the agencies are all going to be customer focused, thinking that you're kind of the evil business guy who's trying to take advantage of the customer. Okay, the question is that basically, is there a way to discriminate, or could, he's not thinking he can discriminate against things.
See what I could do that would be discriminatory. Do you have an example?
Well, you don't have an evil mind, so.
Yeah, I'm working on it.
Okay, well, I don't either, so I'll have to think about it.
Wait a minute, you're working on having an evil mind?
It's hard.
Okay, I'm not sure. Let me think about that one.
I'm just like.
Right.
Remember, this is the federal government. It does not have to make sense.
Okay. All right, great. And then our next is the CP&I security breach notification under the new broadband privacy rules. The old method was providers must notify LEA of CP&I breaches using the CP&I breach portal. The new way is all providers must notify LEA of the breaches of the consumer proprietary network information within 7 days that affects 5,000 or more customers using.
The old rules are now new again. The broadband privacy rules, this section, the lower section, is what's no longer in effect. We added it here to show you what the broadband privacy rules, which are now dissolved under the Congressional Review Act. So the CP&I rules that were in place for years after the 1996 Telecommunications Act are back in compliance, are back in order.
They don't apply to Equifax, obviously.
Pardon me, they don't apply?
To Equifax, obviously.
No, not to Equifax. Equifax is not a common carrier, unfortunately. Neither is Home Depot or any of the other major security breaches, which, by the way, being a privacy and data security attorney, I've been subject to all of those breaches, which is just lovely. So the old rules are new again. They're now the law. So basically, this was reinstated by Congress as soon as practicable. In the event no later than 7 business days, you have to notify the FBI, the United States Secret Service. And then you cannot notify consumers until after you've done your LEA notice, and only then with the blessing of the law enforcement. Now, there are 49 state security breach notification laws. Some of them require notice differently than the federal government does. Note that these federal rules preempt your state laws, but you still are obligated to comply with your state rules to the best you can. So be prepared if you have a major security breach that you may get your state AG or your state regulatory agency wondering why you didn't provide notice under their rules. You are exempt from their rules because the federal laws preempt it. I see a question here. Todd? The question is, are you obligated to do security breach notification? Any CP&I filing? You're talking about the certification filing, the annual filing?
Under the ISP section, since we got separate, we do our own 100% under the CLEC.
Okay. CP&I is Customer Proprietary Network Information under Section 22 of the 1996 Act. CLECs, as well as bias providers, are obligated to file under CP&I. Again, the net neutrality rules have not been voided yet. This commission is trying to get those rules overturned. So you are still a telecommunications provider and a common carrier if you offer a broadband internet access service. So yes, you still have to file CP&I certifications for both your CLEC and your ISP part of the business. You are also subject to the CP&I rules as an internet service provider under the statute. Granted, there's no FCC rules, but the general statute still applies to you, which means you still have a higher duty obligation to keep that customer data secure. So you still must comply with the statute, even though the rules are gone for broadband policy. So you still have other obligations. Yes? The question is, if your customer has services from both the CLEC side of the business and the ISP, is there duplicate filing required? You're talking about notice to law enforcement? No, there isn't. Basically, when you file the notice of law enforcement, you tell them what services were impacted and how many customers, estimated customers there were. And that's an electronic process on the FCC's page. Certainly. Understand that under CP&I, again, you must still be diligent to ensure proper legal authority for intercept and access requests. That's the clear requirement, which we're going to get into. And you must ensure that the sharing, which means any disclosure of customer personally identifiable information and CP&I, is consistent with your privacy policy and your terms of use agreement. As a common carrier, which you are still subject to FCC enforcement under 201B, which is you must have just and reasonable rules. So even though the broadband privacy rules are gone, there are still enforcement mechanisms in place to make you subject to deceptive practices or unjust and reasonable practices. All providers. Speaking of law enforcement. Kalia? You've got that.
Okay, gotcha. Okay. Yeah, I think as Janelle's describing this, I think you kind of can see how complex this is. There's a lot here. I would really strongly suggest that you talk to Janelle, her firm. I know there's another company here that's at the trade show looking at certain things related to CALIA and everything like that. So it's just tough. It's just difficult. There's a lot where one kind of catches another one doesn't. So on CALIA compliance, okay, applies to all telecom and bias providers since 2007. VoIP bias providers must comply with all CALIA requirements upon launch. Now, I've had some clients of mine who've had CALIA implementation as far as the law enforcement comes to them, says they need this certain things. They basically throw up their hands saying, hey, I'm not a law enforcement official, what should I do? And I basically refer them right on to a legal firm right off the bat. Do you give up that information right off the bat or do you not? Well, obviously, as Janelle was just talking about, if you do, you may violate another requirement that's out there. So it's very important, get everything you can in writing so that you can provide it to your attorney so they can walk you through this. There is a requirement to cooperate, but if you cooperate and then you violate something, it's just not too smart. You know what I'm saying? So there's these requirements that are out there to participate in law enforcement. You know, if they want wiretapping or something like that, they have to provide the information. But before you provide it, please consult with your attorney.
Note that the CALIA requirements only set forth the technical standards that you must have your network available for law enforcement to tap into, to intercept. Those are just the technical standards, the measures that you must ensure that your service is available. The subpoena and the FISA request are part of that, but that's separate. So you have to have the technical capabilities. Then when law enforcement comes to call, what the authority they have to request access to your network, under what jurisdiction they have to access your network, and what they're asking for is what you need to really consult with your legal counsel before you comply. And your law enforcement could be anyone from the local police that's trying to catch a child predator that's in the area, or it could be the United States Secret Service or the FBI because of Russia hacking. Believe it or not, we've had some ISPs that have been subject to requests because of this whole Russia investigation. So you need to ensure that that request from law enforcement, even though you may have the technical capability to give them what they want, the question is, do you have the proper legal authority for them to ask for it? That's why you want to talk to legal counsel before you give up anything. I have seen subpoenas that were not correct. They were drawn on the wrong authority, or they weren't signed by the right person. You are then subject to liability if you don't follow the law. Just because it's law enforcement doesn't mean it's right.
Got a lot of questions there.
Yes, sir.
What's the time frame? They give you a subpoena and they'll tell you to get it.
It depends. They will tell you, and it depends on what type of subpoena is. If it's a FISA request, which is a national security one, it could be within 10 to 20 days. And understand, too, that sometimes you can argue with the time frame because what they're asking for is so broad, you can basically work with them regarding that. So it varies. It varies as to when they need it, how they need it, and what they need.
So nothing within 24, 48 hours.
Usually nothing within 24, 48 hours, but again, it depends. If we're looking at child predator, and you want to help catch a child predator, but you also want to protect, your first obligation is protect your business. It depends. Question all across the room? It wouldn't be a CALEA clause because CALEA, again, only speaks to the technical capability of your network. But in your privacy policy, as part of the things that you talk about and how you will disclose personal information, remember that's one of the requirements, how you use, how you collect, how you disclose, how you secure and protect PII, you definitely need a clause that will say how you will comply with law enforcement. And there's some special language that you should use. That you basically want to have some rights and privileges to deny law enforcement requests. You don't want to say you're going to give law enforcement everything. You really need to carefully craft that language. But yes, part of the disclosure of customer information, how and who you will disclose it to should be in your privacy policy. Another question? Yes, sir.
I was going to say, you show that to the judge and the discovery stops at that point.
Okay, there wasn't a real question, but the comment and observation was the importance of having a data destruction policy, that you will destroy any customer proprietary information or any customer personally identifiable information with a certain amount of time, that there could be civil disclosures and civil requests for such data in divorce cases and estrangement cases and lawsuits, for example, under that. Not only is there importance for data destruction policy, you need to mention that too in your privacy policy. And whether you give consumers the right, a former subscriber, do they have the right to ask you to destroy all of their customer file? Now, sometimes you can't give them the right for that because you need to maintain certain records for state and for FCC purposes. So you need to say that too in your privacy policy. If you are restrained by state or federal law, you need to say that you cannot request destruction of your customer proprietary information just because you're a former subscriber. You need to basically spell that out. Sorry, a question here?
Yeah, do you mind if I go?
Well, please.
Hi, Dave Rodecker. I'm with WISP.net. New to this industry, and I really apologize. I ran to this session, so sorry if you already covered it, but I think I wanted to ask and clarify if I'm really concerned about, am I complying with the right policies? I don't want to get sued. I want to be more transparent. Our privacy policy is very specific in which we are pre-disclosing the information that the law enforcement, that we would intend on giving to the law enforcement. So with the exception of billing information. So just to be clear, we collect 4 pieces of information from every customer, and that's all we require beside their billing information. Those 4 pieces of information we will publish actually on our website. So it's
Why?
That's for the purpose of not being in a potential lawsuit or being served with documents asking us to provide more information.
I could argue that that is against your CP&I obligations under the statute.
I'm not sure what that means, but so
That means that you're supposed to keep customer proprietary information confidential unless it's requested by law enforcement. So your publication on the website may avoid you a lawsuit, but it may give you some regulatory action as well. I would
Gotcha.
not recommend publishing any customer's name information on your website. That is proprietary information.
Sure. So we actually don't, I do have to put an asterisk. We don't actually provide name, but we do provide address information,
Why?
geolocation information. Well, that's actually part of our secret sauce as a WISP.net getting into this industry. We use that for our marketing benefits as well. So is there any compliance or risks that I'm taking that you said CPI was the acronym?
Yes, but that's an offline conversation.
Perfect. Okay.
Compliance requirements, note that, don't forget, you have a lovely form that you need to keep updated with the FCC. And I know we're past our 10 o'clock, but I've got one more item that we must talk about because you could be subject to very serious liability, so just bear with us, and I do appreciate you staying past the 11 o'clock time. This is your system and security integrity plan. If you haven't filed one recently and your network has changed or you've got different people in place, this needs to be updated with the FCC. This is confidential. This is not posted anywhere on your website. It is not available to consumers. This is purely for law enforcement to use. This is what's filed electronically, or really filed, not even electronically, this is filed through a private, a separate filing with the FCC and kept confidential. More compliance requirements that you can go to in our actual list. And you can use a trusted third party. There are very good vendors here that will provide CALEA compliance, as well as vet law enforcement requests. They will actually vet a subpoena or FISA request or whatever for you. This is the last thing we really want to cover. DMCA, Digital Millennium Copyright Act. If you don't remember anything else, remember December 31 of this year. This is the filing deadline, the new electronic database that the Copyright Office has now created, that you have to re-register your designated agent. If you don't know what DMCA is, let me give you a quick overview. This is under Section 512 of the DMCA Act. It basically is a provision that gives you protection from legal liability when third parties violate copyright. These are your consumers, these are your subscribers, these are the ones that are doing peer-to-peer filing or downloading unlawful content using your network. You, as a service provider, have protection from liability when a copyright owner comes to call and says that you are responsible for violating their copyright. You have protections under the DMCA, but only if you do certain things. One of those first prerequisites is to file to register a designated agent with the Copyright Office. Basically, your DA and a specific content information, these are the new requirements. That designated agent, you have to have, first of all, the full legal name and physical address of the service provider, which would be you. Your alternative names could be the different limited liability companies or the different subsidiaries or different web internet addresses. Your internet addresses could be various. The name of the DA now can be an individual, it could be a title or a position, it could be a department, it could be a third party. That's new. I have served as the designated agent for over 400 broadcast stations. And I had to put my full name in there, and I actually used a different email address because I can't tell you how much spam I got, particularly when it comes to men's things on my email address. But now it could be DMCA Copyright Department. So you can designate a department and have a general email address. This basically designated agent is used for a copyright owner to check the Copyright Office's database and see who the person or entity they contact if they have a complaint. That's what that DA is. It's basically a person that will accept a complaint from a copyright owner. There is a, go to copyright, Google Copyright DMCA. It's an electronic database, electronic portal under the Copyright Office's page. Yes. Well, first of all, there are certain requirements that a notification needs to be not only substantially compliant. There's certain basic things that if you get that copyright notice, that's one of the things you should also put in your terms of use agreement, or what the notification requirements are. Not only do they need to certify that they have the right to ask for that, but they have to give you idea of where that potential infringing person is. So if they don't meet those requirements, you don't have to comply with them. But you should list out what those requirements are and state in your terms of use agreement that if you don't have this information, that we will not respond, or that your notice is not sufficient enough. The question is, if you get the notice, is there a checklist? Yes, there's a statutory checklist, which is what should be listed on your terms of use agreement. You can just pull the language right off of the DMCA section 512, and you can use it to check what complies, what doesn't comply. Yes. Well, yes, because unless you have a separate copyright policy, and some entities decide to do a whole separate DMCA notification policy that lays out who your DA agent is, what your requirements are, where to send it to, and all that, you have to incorporate it into something. You need to make it available. So the next best thing to make it available is your AUP or your terms of service agreement. As long as it's posted somewhere on your website, your designated agent posted on your website in terms of contact information needs to be same that's filed with the Copyright Office. Well, I think, now understand that these requirements, again, you need accurate, I can't emphasize this enough, accurate information. Both of them need to be exactly the same. So if you've not reviewed your designated agent filing with the Copyright Office in some time, compared it to what's posted on your website, if you've acquired a new company, if you've been bought, if you've sold someone, I would say double check today, because you would have lost the safe harbor as of the date your policies were not up to date, which means you don't get the protection from liability. Again, you must re-register your information with the USCO no later than December 31st. As of January 1, what you filed paper is no longer valid, which means you lose your safe harbor protection. There was a question? Well, first of all, terms of service, service agreement, terms of use, AUP, is separate from a privacy policy. Your privacy policy should govern your practices throughout the company, whether it's online collection, offline collection, no matter how you use customer data. Your privacy policy covers everything you do, you touch, you use customer information. Terms of service, terms of use, AUP is pretty much oriented towards the service. But understand you've got two things going on there. You have a website and you have the actual service provides. The website terms of service dictates to people how they access your website and what liabilities have if they steal data off your site, if they try to shut it down. You want a terms of service to control how anyone uses and accesses your website. That's where your DMCA policy would be. Your terms of service, terms of use, AUP agreement dictates the terms of the actual internet service, VoIP service, video service you're providing. Really are two different types of services. I've got clients that have just terms of service for their actual service, but their website is totally unprotected. There are different terms and things that we put in to protect your website from legal liability and from misuse and abuse, as separate from how you are indicating what you offer customers when it comes to your actual ISP service. Follow-up question?
Yes. Just in the same way that I don't know how my website could be misused, I don't know how to go against somebody disabled.
Someone could disable it, someone could hack into it, someone could lift whole provisions off your site and post them on their own site. But
I mean, it has my name and where we're located. That's pretty much it, but there's more to it that needs to be protected.
well, again, if your website is being used to solicit marketing and customers, and you've got a portal that allows customers to click a link or to subscribe or to even pay their bill or whatever, you're going to need obviously higher protections than you would if you're just using it for marketing purposes. It makes a difference whether that site is active or interactive. Okay? Certainly. One more. Also key in terms of requirements for keeping your safe harbor: designated agent filed with the U.S. Copyright Office electronically by December 31st, same information posted on your website, but you must also have a repeat infringer policy. This is the hardest part for ISPs, because we understand that the people that are infringing your copyright and of the things are your customers. It is hard to shut off a customer. I understand that. It is very difficult to give a notice to a customer that there's, maybe it's it could be NBC, it could be any of the other providers, broadcast providers, with their streaming improperly. They're repeat infringers. You need to have an internal repeat infringer policy that dictates when you will turn off a subscriber. You will shut down a subscriber. Not only do you need to have that in writing, you need to enforce it, and you can't be inconsistent in enforcing it. Cox Cable was subject to a $25 million jury verdict and then $8.38 million in attorney's fees because they had what was called a soft termination. They would shut the customer down for a day or two and then just said, just give us a couple days and we'll put you back up again. This was after receiving multiple requests from B&G Music or some other music provider that customers were infringing their copyrights. You need to maintain, you need to protect, and you need to make sure everyone in your chain of command, when it comes to taking down or looking for subscriber infringement, needs to honor your internal infringer policy. Yes, sir.
It's my understanding that there really isn't a specific policy in terms of DMCA's, and you have one. But
There is no set number. Do they do it too? The question is, there's no specific policy as to what's called a repeat infringer.
So consistency is what got Cox.
Consistency and lack of enforcement is what got Cox.
So what enforcement is required? I guess that's the question.
Well,
I don't think there was much besides notifying the end user, that you had DMCA, I guess.
Well, no. If you have a repeat infringer policy, you need to know. For example, there's some providers, and this goes across the board, that if you get a notice, and the question is it a notice, a claim of copyright infringement, or is it duly adjudicated? I mean, is it proof of it? The question is, if you've gotten 10, 12, 14, sometimes in this Cox case was hundreds of notices that these particular subscribers were infringing on a particular site or particular content, that you need to notify the subscriber and then basically take them offline to disconnect that particular subscriber. Cox not only didn't notify them, but when they were forced to notify them, they said, we have to take you off the system for a couple days, but then we'll put you back on. So they didn't honor their own repeat infringer policy.
But I guess what I'm asking is, in developing the policy, is there a number?
There is a number. You need to decide internally within your company as to what constitutes a repeat infringer. Is it 3? Is it 6? Now, Unfortunately, you can do 100, but is 100 reasonable? I would say no. That's the problem with this. We don't have a fixed number. There is no statutory number. That's the problem. There is no regulatory number. We only have to look at what the lawsuits have been and what the industry has done on an average range. There's a question back here.
This lady right here has been waiting for.
Oh, I'm sorry. Go ahead.
Go ahead, lady.
Cheap part.
Yeah, I think what you're looking for is you're trying to see if is there a grid or is there a sheet that basically you can check off to make sure you get all these different policies handled at one time.
Different policies, as in all the things you have to do for forms and whatever?
Forms, kind of just like a sheet so to make sure we're on schedule.
No, there isn't. Basically, it's this presentation.
I tend to get this.
That's why we try to put a little more detail in here. Unfortunately, there is no checklist. Yes, sir. There is no database because we're talking about individual customers and individual subscribers. Unless that person has been litigated as a serial infringer, you really wouldn't know. The only way you would know that this person is a constant problem is when you get that first notification from the copyright owner that may inform you that this person is the same person that's also violated, how many other ISPs. So unfortunately, you really don't know. But that's also the other part that needs to be in your terms of service agreement and in your privacy policy. Your privacy policy should basically say, if you are deemed to be a repeat infringer, and you don't have to detail what repeat infringer is in your privacy policy, we will disclose your subscriber information, whatever, to the copyright owner and to law enforcement. So someone knows that you'll give up their data to someone who's complaining. Same thing in your terms of use, whether it's your service or for your website. You need to say that you will be disconnected or you will lose your privileges if you are deemed to be a repeat infringer. You need to give notice for that. So when the copyright owner, and they have become very active, particularly after the Cox case. Again, Cox was operating as an ISP and ignored their own internal policies and spent millions in defending themselves and then millions in having to pay the legal fines. Yes, sir. Well, the question was, is there a difference between an adjudicated infringer or someone that provides a notice, and what other standards pretty much are required?
Offender, if you get 3 notices in a year and no provable, demonstrated action.
Well, I don't know. First of all, you said you could a person get 3 notices in a year and there's no provable action. The issue is if you get a notice from a copyright owner that a particular subscriber or particular entity is infringing their copyright, you have to basically take down or dissolve that, give notice to the subscriber. Okay, at least the first notice. Now, they have a right to counter appeal. They have a right to say, no, I'm not infringing. No, I'm not, and I've accessed this data pursuant to legal authority, whatever. Those type of counter appeals I wouldn't count as part of repeat infringers, because I do agree there are copyright owners that are just abusing the DMCA process. There's no doubt about it. Accusations are not sufficient enough. They have to follow the statutory list of what the notification must say. So if they don't follow the statutory list, you don't have sufficient information to do anything. And you also don't have an obligation to tell them what they're missing. You just say, I'm sorry, this notice does not meet the statutory requirements, and end it at that. DMCA can cost you hundreds of thousands of dollars if you don't comply with it. Yes, there are some problems with trying to notify your existing subscribers, particularly those who may have a teenager that's just accessing all kinds of stuff because they don't know that everything on the internet is not free. But you have an obligation, otherwise you lose the safe harbor, and the safe harbor can protect you from serious liability and serious costs. Yes, sir.
Is there any recourse to those operators that might be abusing the system?
Yes, there's penalties. They're subject to federal penalty. In fact, you should put that whole section that talks about the penalties. We add that to every terms of service for the website that speaks to if you are not authorized, first of all, authorized to contact us with a notification of infringement, or you have basically lied, then you're subject to penalties. And I would report them to the government, and you can also do a countersuit if you need to. But there are serious potential liabilities for lying for copyright infringement. But your overall obligation is just to post this information on your website, follow your own internal policy, and you'll have more protection than you can use. Any other questions?
In those terms, can I dictate the venue so that I don't have to go to Washington to fight a big corporation, but they have to come to my county?
Well, that's where your venue and your jurisdiction provision lies in your actual terms of service agreement. That's why a terms of service agreement for your website is just as important a terms of service agreement for your service. That you dictate where your venue and your jurisdiction and your law allows on your website. That any issues regarding your website or whatever, or your service, you want them in both. Again, there's certain particular legal provisions. There's reps and warranties. There's also indemnification provisions that you want to have in both agreements. There's certain, the boring legal terms that will serve to protect you when you're in trouble. They're a pain in the butt to write and pain in the butt to add, but they serve a purpose. They really do.
Personally, in past experience, when you're fighting a big multinational corporation and they figure out they have to send an attorney to your little town, they'll make a deal real fast.
This just highlights the counter notifications, and now we're at the additional questions. Yes, sir. Right, and many WISP have dynamic systems like that, and you basically need to notify the person. Same thing with law enforcement. When law enforcement wants a particular IP address, you need to just tell them that you're not able to secure that for a particular person because that's not the way your system works. You cannot give up the entire database to law enforcement or to someone who's claiming copyright. You basically need to let them know that you're not able to identify this particular infringer merely by IP address. You need more information. Okay. Well, thank you, ladies and gentlemen.
Yeah.